Hello friends, welcome to ProTalent, and this is Nitin Parmar, and we are talking about absolute liability, session number 12 for law of torts. In this session, we are going to understand the concept of absolute liability. I'm sure all of you remember what we did in our strict liability. There was a principle which was saying that if you have your land, you enjoy your land in whatever way you want to do it, but you do not disturb others. That means you have your rights, okay, you can exercise all your rights, but you have duties towards others. दैट मीन्स अगर आप अपने राइट्स एक्सरसाइज करते हैं, ठीक है, दैट मीन्स आपकी लैंड एंजॉय करना चाहते हैं तो आप उसको एंजॉय कर सकते हैं, पर किसी को नुकसान नहीं पहुंचाएंगे, और अगर किसी को नुकसान पहुंचेगा तो आप जिम्मेदार होंगे. और यही था कंसेप्ट स्ट्रिक्ट लायबिलिटी में, जहां पे आप कोई नॉन नेचुरल यूज कर रहे थे अपनी लैंड का. दैट मीन्स आप डेंजरस एक्टिविटी अपने लैंड पे लेकर आए और वो एस्केप हो गई, एस्केप होकर किसी को डैमेज हुआ, दैट इज कॉल्ड अगेंस्ट स्ट्रिक्ट लायबिलिटी. नाउ द कंसेप्ट इज डेवलप फर्दर विद एब्सोल्यूट लायबिलिटी. देखते आगे क्या होता है. सबसे इंपॉर्टेंट प्रिंसिपल हमने बात करी, दैट इज सिक उतेर टू यूटेलिनियम नॉन लेदास. ठीक है, दैट मीन्स एंजॉय योर ओन प्रॉपर्टी इन सच अ मैनर एज नॉट टू इंजर एनी अदर पर्सन. दिस इज वेरी इंपॉर्टेंट, और ये सीधा एप्लीकेबल हो जाता है फैक्ट्रीज के लिए, और वहां से कंसेप्ट डेवलप होता है एब्सोल्यूट लायबिलिटी. सो एब्सोल्यूट लायबिलिटी इज अ न्यू कंसेप्ट. While in 18th century strict liability डेवलप हो चुका था, absolute liability 28th century में डेवलप हुआ, and majorly it was developed in case to case basis in various countries including in India. This rule in our country is laid in a very famous case called oleum gas leak case. Okay, it is laid down by Supreme Court. This is an understanding which was created by Supreme Court in this famous case. Let us understand exactly क्या concept develop हुआ absolute liability में. यहाँ पे एक enterprise के बारे में बात होती है, तो ये ध्यान रखना, this is primarily towards enterprise. This is nothing else. ठीक है, कोई एक इंडिविजुअल पर्सन की बात नहीं है, एक एंटरप्राइज है which is for profit activity which is happening. It is engaged in hazardous or inherently dangerous activity. Then the enterprise is strictly and absolutely liable to compensate all those who are affected by the accident. Such liability is not subject to any exception. This is a rule provided by Supreme Court in our country. The enterprise cannot escape any sort of liability, showing that we have taken all reasonable care. Even enterprise has taken reasonable care. उसके बावजूद अगर कहीं प्रॉब्लम हुआ तो इट इज एंटरप्राइज इज एब्सोल्युटली लायबल. ठीक है, ये प्रिंसिपल बहुत रेयर केस में अप्लाई होता है. एक फेमस केस था भोपाल गैस लीक केस, वहां पे ये अप्लाई करने की जरूरत पड़ी थी. ठीक है, पर उसके बाद एक और बड़ा केस हुआ जहां पे ये एक्चुअली में अप्लाई हुआ. ठीक है, क्या केस हुआ था समझते. दिस इज कॉल्ड MC मेहता वर्सेस यूनियन ऑफ इंडिया केस. Shriram Food and Fertilizer Industry, it was a subsidiary of Delhi Cloth Mills Limited, was producing some caustic and chlorine material. On December 4th and 6th of 1985, major leakage of oleum gas took place from one of the units of Shriram Foods and Fertilizer, in the heart of the capital city of New Delhi, which resulted in the death of several people, including one practicing lawyer at Tis Hazari Court. The leakage was caused by a series of mechanical and human errors. This result of collapse of structure on which it was mounted, and it created a scare amongst people residing in that area, and thereby people really worried about it. Hardly had the people got out of the shock of this disaster, within 2 days another leakage, this time though it was minor one, took place, and this is oleum gas leak case created trouble, havoc in the mind of against Delhi people. On 6th of December 1985, the District Magistrate of Delhi under Section 133 of CRPC directed that Shri Ram will have to cease their operations in 2 days ठीक है, primarily on their occupation of manufacturing and processing of hazardous and lethal chemical gases including chlorine, oleum, superchlorine, phosphate, etc. at this Delhi establishment, and within 7 days they have to remove all such chemicals and gases from the Delhi. At this juncture, a very important person in the legal history called Mr. M.C. Mehta moved Supreme Court to claim compensation by filing a PIL for the losses caused and pleaded that the closed establishment should not be allowed to restart. So this is Mr. M.C. Mehta. ठीक है, Mahesh Chandra Mehta is a public interest attorney from India. He was awarded this Goldman Environmental Prize in 1996 for his continuous efforts in Indian courts against pollution causing industries, and he also received this Ramon Magsaysay Award for Asia for public service in 1997. This is M.C. Mehta. ये केस के द्वारा, ठीक है, सुप्रीम कोर्ट ये रूल पे लेकर आई दैट एब्सोल्यूट लायबिलिटी इज वेरी इंपॉर्टेंट कंसेप्ट. और एब्सोल्यूट लायबिलिटी किसके ऊपर लगता है? इट इज एप्लीकेबल ऑन द एंटरप्राइज, एंड एंटरप्राइज के ऊपर ये एब्सोल्युटली लगता है. नो एक्सेप्शंस आर प्रोवाइडेड, नो काइंड ऑफ यू कैन से सपोर्ट टू बी प्रोवाइडेड टू एनी such kind of against enterprises. So overall, if people try to think about what is the difference between strict liability and absolute liability, हमने बात करी थी strict liability में liability is arising out of non-natural use of land, while in the absolute liability, liability arises out of the hazardous activity of an enterprise. So very important part, it is for profit organization. This is very important. Number 2, strict liability is subject to various defenses. Effectively 5 defenses are provided. Here there are no defenses. There are no defenses to be provided, and there is generally substantial damages are awarded in this strict liability case, while in absolute liability, in addition to substantial, there are exemplary damages. What are the exemplary damages? Damages जो substantial है, that means जितना नुकसान हुआ उसके ऊपर थोड़ा सा ज़्यादा, that is called substantial. But exemplary, example देने के लायक मतलब थोड़ा सा और ज़्यादा, that is called exemplary damages are being provided. Yes, ठीक है. So here in absolute liability, no defenses, it is applicable to enterprises, and here exemplary damages are provided. Remember, very important part, generally these damages are directly proportional to size of the enterprise. Okay, size of the enterprise. भारत में जब भोपाल गैस लीक केस हुआ था तो साइज ऑफ एंटरप्राइज देखा गया था और लोगों को इंडिविजुअल कंपेंसेशन देने की बात करी, और वो पूरी की पूरी संस्था को वहीं से निस्ते नाबूद कर दिया था. ठीक है, सो दिस इज हाउ द एब्सोल्यूट लायबिलिटी इज अप्लाइड. ओके, सो स्ट्रिक्ट लायबिलिटी एंड एब्सोल्यूट लायबिलिटी, देयर इज अ बिग डिफरेंस. आई होप with this video you have understood the idea of absolute liability. Okay, chali great. So with this I'm closing this module. Make sure that you get this PDF from ProTalentDigital.com. We have one more video which is coming called against vicarious liability, and by that we'll be closing the entire issue of law of torts. Okay, thank you very much and all the best.